above, list after the vacations.
Much obliged, ma'am.
Your Lordship, Part 2, Item number 6. With the consent of the other parties, can this matter be taken up after 2 weeks?
Consent taken.
Yes, my Lord.
Miss,
Miss Arvan Shoaizeli,
item number 6. You're appearing on behalf of?
the petitioner.
Your name is not there?
No, my Lord. I'm standing on behalf of my senior, Mr.
Yes.
Efla Engana.
Mention is made on behalf of Mr. Eflal Engliana, learned counsel for the appellant, for adjournment of the matter with the consent of the other side. In view of the above, with the consent from, okay, the other side. In view of the above, list after the ensuing vacation. Yes.
Much obliged.
Daily list for admission, item 1.
May it please your Lordship. My Lord, this review is relating to that interpretation of Section 96 and 97 of the Mizoram Land Revenue Act 2013, wherein the concerned department...
We'll hear this afterwards.
My lord.
Let's do the others, because this will take some time, isn't it? There are matters for orders and all that. Let's fix that.
Very well, Your
Review. What is 2? 2 is, I think, quite simple.
Item 2.
It didn't take time. Because it's concerning service.
My Lord, I think this is also going to take time. It's on admission hearing.
It is...
It's been listed for admission hearing.
Yes, ma'am.
Pleadings complete.
Pleadings
We'll
are-
list it
pleading
after the listing vacation.
My Lord.
I don't think there's any great urgency. We'll fix a date.
Yes. Let's have
Because nothing is mentioned here. Mr. Lalpianfela Chongto, learned counsel for the petitioners, is present, along with Mr. C. Lal Fagzola, learned counsel for
Private respondent.
private respondents number 7 to 24. And Ms. Who's the counsel for the government state?
Miss Vanessa is there.
No, she's not. Okay. Along with Mr. C. Lal Fagzwala, learned counsel for the private respondents. It is submitted by the learned counsels that pleading is complete. In view of the above, list this matter for admission hearing after the ensuing vacations. You want a date? We will fix a date.
15 July.
On 15th, what is 15th? July, okay, Tuesday. On 15th, 7, 2025. Yes.
My Lord, I'm sorry to say this out of turn. Yesterday's case, I'll just place before the bench clerk regarding one citation which was relied by Leonard Fred. I'll just place the paragraph.
Okay, what was yesterday's case about?
That is with regard to that promotion case. I'll just place
Okay.
I'll just place the paragraphs.
Citation.
Yes, it's already relied by the
Okay.
petitioner.
You have mentioned in yesterday
Yes,
concerning
it's
that.
already there.
Okay.
I'll just write the paragraph.
Item 3.
So put it in the file.
Lordship, as directed, we have taken steps against the other respondents, 2, 3, and 4. And on the last
2, 3, and 4. Are they represented?
newspaper publication was done, and they are still unrepresented. And
Who is for 1?
one
I'm for
Yes.
respondent 1, my lord.
You are the claimant.
claimant, yes. So
2,
in that
3,
case, a
and 4.
newspaper publication has been done. It has maybe
What is the appeal regarding?
the appeal is regarding the issue of insurance policy being fake.
Okay, so it's covered under 149.
Yes.
2. Yes?
Yes, it is a fake policy. The stand of the company is that. So the service against the other respondents may be deemed to be completed. And then we can take up
this thing in the. Oh, wait, these ACT cases.
Yes,
Now there's going to be this mediation. Okay, a national mediation, where it is suggested that all the MACT as many as possible MACT cases should be referred for mediation. So, but yours is concerning
this
the.
case, highly not possible, yes.
Not possible to settle.
On 13/6,
But then what can happen is, it can be settled, okay. Not valid insurance, can it be pay recovery?
no,
If it is, I don't think it
no.
can, it's
It is the
possible.
sole responsibility of the owner.
Okay, then, you'll have to find, because supposing insurance company, on what grounds insurance, this thing, a fake insurance this thing? You're saying that the insurance is a fake or what?
Yes. In this case, what has been
So
done?
was it that matter raised before the
Yes,
tribunal?
evidence was also adduced by the company, one of the representatives,
Oh,
saying that
but the tribunal found that it is not fake?
yeah, on that ground, on that point, no further discussion was made. So it has to be appreciated here. So on 13/6, this
So
court,
see if you can, that someone died in the accident.
yes,
If there's a death involved, they have to be compensated.
now,
And the
yes.
matter was raised before the court's tribunal. Tribunal did not found it appropriate to consider that maybe for some, on some grounds. Now, it is not the fault of the claimant.
Yes, either the owner,
What is the address of the owner? See, we have to see how the claimant will be compensated. If it's because of the accident, rash and negligence they have suffered. Resident of Lunglei Tourist Lodge. Have you attempted Dusty, through Dusty?
no, a newspaper publication was done.
Then attempt through Dusty, because this is a Bongkon. No, Bungkon. It's Bungkong, Aizol, and
Bunkon is the driver of the scooty.
and the owner also, residents of Lunglei Tourist Lodge.
2 and
So
3.
newspaper publication is done in which newspaper?
Banglaini.
Wanglaini, it's not so this thing in Lunglei. It should be in a newspaper which is widely published in Lunglei, local newspaper. So you make an attempt through Dusty, isn't it? You must be having a branch there.
Not
Insurance
I need
company.
To find out. I need to find out.
Make an attempt,
To find out.
because how will the claimant, supposing your appeal is allowed, we're not saying it's going to be allowed, but supposing in the event that we find that the insurance policy is fake, we have to see how will the claimant who has suffered in the accident be compensated, isn't it?
Yes.
Nothing of, okay. So you make an attempt first.
Yes.
Wanglaini, but one isn't from Lunglei.
Yes.
Then the owner should be a local newspaper in the Lunglei also, widely distributed. The Wanglaini is taken in Lunglei, but they have their own local newspapers out there, Lunglei, which is also widely. So you make an attempt, another attempt. Okay.
Yes.
Heard Mr. Roshan Subedi, learned counsel for the appellant, along with Miss
Valil Thamwani.
Valal Thamwani, learned counsel for the respondent number 1/claimant. It is seen that respondents number 2, 3, and 4, who are the owners and driver of the accident vehicle, remain unrepresented till date, though newspaper publication was made for service of notice and affidavit to that effect has been duly filed. It is seen that the instant appeal is with regards to the authenticity of the insurance. Is it? What's it? Insurance
Insurance policy.
policy. And that the insurance company is not liable to pay the awarded amount also. This court find it appropriate that an attempt should be made for service of notice upon the respondents through dusty mode, since it is seen that no such attempt has been made previously. In view of the above, the learned counsel for the petitioner is to take steps for service of notice upon the respondents number 2 to 4 through dusty mode, and affidavit to that effect is to be filed accordingly. List after 4 weeks.
Item 4.
In this case, Your Lordship, we have taken steps and no return has been received till date. So we may await for some time.
Okay. Now we are searching for cases to send for mediation. But notice is not
Not
complete here.
completed, yes.
Heard Mr. Roshan Subedi, learned counsel for the applicant, who submits that return of service of notice to the respondents is still awaited. In view of the above, we may await for return of AD card from the respondents list after 3 weeks.
Item 5 for orders.
What's this?
Yes, Your Lordship, I believe the petitioner counsel is not present
None
today.
appeared for the applicant on call, while Ms. Avani Isyami, learned government advocate, appears on behalf of the state respondents. In view of the above, list after the ensuing vacations. Yes.
Item 6.
Yes, Your Lordship, the matter was taken up by Miss Mary and now she is on her way. And if the matter may be passed over for the time being.
Okay. Time being matter.
Yes, Your Lordship.
Item numbers 7 to 9.
May it please Your Lordship, I am for the appellant. Item number 7. My Lord, with regard to item number 7 and 8, notice are completed. And regarding item number 9, in the previous order, I was directed to serve a notice to Dusty. And my Lord, I have already served notice. However, if I may be allowed to file an affidavit service report within this week, my Lord.
So can these matters be referred to the Singh Lok Adalat? What is the appeal about? United.
My Lord,
Is it on the quantum?
yes, no, my Lord. My Lord, the claim was filed under section 166 MACT.
So
That requires negligence on the part
so
of
you
the-
try and settle the matter in mediation, isn't it?
Yes.
Yes, you're for the respondents, claimant. Because a lot of MACT cases can be settled without looking into the technical aspect. If it's found that there was an accident, someone has been hurt or someone died, see how they can be compensated. Isn't it?
My Lord, can we just have a discussion
Okay.
with the company?
Okay, yes. So you will we'll fix it immediately after the vacation because it is during this month, July, that we have to refer cases for mediation.
Miss me.
In the meantime, file your Dusty
Yes, my Lord.
affidavit.
Yes,
Isn't it?
Yes.
Heard Mr.
Arler Watfella.
R.L. Rothfeller, learned counsel for the applicant, who submits that notice is upon the respondents is complete. This will be number 7, okay? And that is complete through Dusty mode, and affidavit to that effect has been filed. Then, Mr.
Michael Patrol, for all the respondents' claimants.
Okay, Mr. Michael Pachov, learned counsel, appears on behalf of all the respondents. Full stop. It is seen that the instant appeal is filed challenging the order of the learned tribunal with regards to the quantum. Here it is quantum, the first one.
Yes,
Because
my lord.
income, okay,
Yes, yes.
of the award made by the learned tribunal. In view of the above, this court finds it appropriate that this matter should be, this court finds that this matter appears to be a fit case to be referred for settlement through mediation. Full stop. The learned counsel for the appellant has prayed for time to get instructions in this regard. In view of the above, list on, we'll make it 17th.
Yep.
By that time, get the necessary instructions. List on 17/7/2025. Yes. Same order here?
Yes, my lord. Same.
You're appearing?
Yes, Lordship.
Okay. Same order for item number 9.
8 and 9.
Okay, 8 and 9, same order. Then in item number 10, 7 and 8, same order. Now, in item number 9, are you appearing for the respondents?
Yes, Lordship.
Okay, so Dusty affidavit is not required because he's already appearing.
My lord,
I am for the respondent number 1 and 2 in the item
Okay,
number 9.
so it's 3.
yes, my lord.
Okay, Mr. So-and-so, learned counsel for the appellant is present along with Mr. So-and-so, learned counsel for respondents number 1 and 2. The learned counsel for the appellant submits that he may be given time to file the affidavit showing that notice was served to respondent number 3 through Dusty mode. Praise the Lord. List the matter after, list the matter on 17/7/2025. Full stop. It is also seen that the instant case appears to be appropriate for settlement through mediation. Accordingly, the learned counsel for the appellant is to get instructions whether this matter can be listed for settlement through mediation. Then, after that, list the matter on 17th. Okay? Yes.
Right.
Item 10.
Lordship, in item number 10, notice upon the respondents number 1 and 2 are completed. We have served to the Dusty. And respondent number 1 is already,
Represented.
respondent number 3 is already represented. And respondent number 1 and 2 serve notice through the dusty.
Then we'll have to wait for them to be represented.
Lordship, yes, yes.
Mr. Johnny L. Tauchung, learned counsel for the appellant, is present. It is seen that notice upon respondents number 1 and 2 is served through dusty mode, and affidavit to that effect has been filed, wherein it is seen that notice was received by respondent number 1 on 23, is it?
23, Lordship, yes.
23/6/2025, and notice was received by respondent number 2 on 26/6/2025.
Yes.
In view of the above, notice is deemed to be complete upon respondents number 1 and 2. However, none appeared for respondents number 1 and 2, while Ms. Lalropari appears on behalf of respondent number 3. We may await for the respondents number 1 and 2 to be duly represented, lest after the ensuing vacations. Yes.
Yes. Lordship,
Item 11.
Lordship, same order may be passed. This is an analogous case.
Okay, so the same.
Same
three,
order.
1 and
Yes,
2?
1 and 2, Lordship.
Same date?
Same
Okay.
date, same.
Same order.
Item 12.
Lordship, here office order indicates that notice upon the respondents number 1 to 3 is not complete, Lordship. The ID card is not returned. So we may wait for some time, Lordship.
IA is for limitation.
Limitation, 46 days.
Okay, I heard Mr. Johnny L. Tauchung, learned counsel for the applicant/appellant. It is seen that AD card from respondents number 1 to 3 is not returned till date. We may await for return of AD card from respondents number 1 to 3. List after the vacations. Yes, ensuing vacation.
Lordship, yes.
Item 13.
Lordship, in this IA, Lordship.
Withdrawal.
Yes, yes. Disbursement of the
amount.
50% of the awarded amount of rupees 12,76,500, along with interest, if any, Lordship, which was deposited by the insurance company.
So it has been disposed of.
Lordship, yes, the connected MACT appeal was already disposed
Okay,
of
so
via
you have
court.
preferred of appeal or not? No.
This stage, no.
No, then we'll allow. When was the judgment?
Judgment
Very
was
recently.
passed on 12/6/2025. 12/6/2025. June.
June. So appeal period is not over.
Not all, 90 days.
Not over yet. But we'll allow. I don't
I have
think
no
you'll appeal.
instruction to that effect.
So
I
you
leave
had
it to
prayed
you
for
lot.
instructions, no instructions till
Yes,
date.
no, the
isn't
last
it?
court date.
I leave it up to you a lot.
So it's okay. Now, heard Mr. Johnny L. Tauchung, learned counsel for the appellant, the applicant.
Applicant, yes.
Also heard Mr. Sudan Rubedi, learned counsel for the respondent's number, insurance, respondent insurance company.
CBS.
The learned, okay, full stop. This is an application filed under section 151 CPC for disbursement of 50% of the awarded amount, that is rupees 12,76,500, along with the applicable interest, which was deposited in the registry on 22/03/2024 in IA within brackets civil number 73/2023 arising out of MAC appeal number 3/2023 within brackets D. Okay. The learned counsel for the applicant submits that the connected MAC appeal number 3 of 2023 was heard and dismissed by order dated 2025. However, the 50% of the awarded amount which was deposited into this court is still kept in the registry, though the awarded amount was to be disbursed to the applicants via the judgment of the learned tribunal in MACT case number 47/2019 dated 08/12/2022 and which has been confirmed on the dismissal of the appeal filed in MAC appeal number 3/2023 within brackets D by the insurance company. Full stop. Mr. Roshan Subedi, learned counsel for the respondent insurance company, submits that he has received no instructions till date whether the insurance company will be preferring an appeal. Full stop. In view of the above submissions, considering the fact that the MAC appeal number 3/2023 within brackets D has been dismissed by this court finds it appropriate that the awarded 50% of the awarded amount, that is rupees 12,76,500, deposited into the registry on 22/03/2024 in IA within bracket civil number 73/2023 arising out of MAC appeal number 3/2023 within brackets D should be dispersed to the appellant by the registry after due verification. Okay, the amount, okay, along with the
Interest.
interest should be dispersed to the appellant after due verification.
Lordship, I have one more prayer, Lordship. I have mentioned in that my IA. So the other 50% may be deposited to this registry.
Already deposited. isn't
Already
it?
deposit is about to disburse, but another 50% is still remaining, and that may also be deposited before the registry.
On the prayer made, okay, you should have made that prayer before, isn't it?
That is usually done in the trial court. So the trial court, they have given all the details of the accounts.
The
So
copy,
it's with the
so you
company.
make an application
If
before the
payment
trial
will be
court.
done, it will be done in the trial.
It's not there in your this thing. Is it there in your
Yes,
application?
yes, it's there, Lordship. I have a prayer. I have a two prayers, Lordship.
Your lordship, the trial court judgment is there in the last.
But however, the problem is, Lordship, 50% is already deposited here before this registry. Then usually the other 50% is
Where's your prayer?
prayer is, Lordship, in my prayer portion, which is at page 6.
It's the same thing where, which this thing is that MAC,
Yes, in this IA, Lordship, I have two prayers, and
it's the same thing, he's
Same
going to
thing.
get them, okay.
yeah, the
So, before Mr. Roshan Subedi, okay, what is the last sentence? Before mentioning Mr. Roshan Subedi's name. Before that, one sentence. Okay, before Mr. Roshan Subedi's name, okay, another subpara. The learned counsel for the applicant. Okay, just type it, I'll correct it later. Has also prayed that the respondent please sit down and take the note. The learned counsel for the appellant has also prayed that applicant, okay, the learned counsel for the applicant has also prayed that the respondent number 1 / insurance company may be directed to deposit the remaining balance from the awarded amount was, what is the awarded amount?
Lordship, 25,53,300, 25 lakhs and 53,000.
Of 25 lakhs 53,000 with an interest of 7% per annum from the date of filing, that is 05/09/2019, into this registry. On the dismissal of the MACT number 3 of 2023. Okay. So now you come back to the last dictation. The respondent insurance company is also to deposit the remaining balance from the awarded amount of rupees 25 lakhs so and so in MACT case number 47/2019 into the registry within 3 months of receiving the certified copy of this order. Yes.
And Lordship, the registry may also be directed to disburse when the amount is deposited. Otherwise, I may be instructed to file another IA for taking out
For
of
what?
that money.
For what? No, that will be deposited and dispersed.
So that may be one line, maybe added,
And
Lordship.
accordingly dispersed. I'll pass. Leave it. Now next.
Okay.
Admission, item 1.
Yes.
May it please your lordship. My lord, this case, as far as the facts of the case is concerned, the trial court did not enter into the merit of the case, so there's not much to adjudicate as far as the facts are concerned. It's basically the question of jurisdiction of the revenue court versus the civil court. And during the course of the appeal, as well as the present review petition, certain clarifications were sought from the concerned department, that is the revenue department, regarding the jurisdiction of the revenue court. At the outset, your lordship, I would like to take your lordship's attention to section 96 of the,
No, before that,
yes, your lordship.
the order that requires to be reviewed is where?
Yes, your lordship.
What is wrong with that order and why does it require to be? What was the order? Let's find.
The relevant,
And how is it connected with the instant clarification that is given?
no. The relevant page is at page 17, annexure 1. That is the copy of the judgment and order. And
Now, after this clarification, how is it to affect the judgment and order which was
yes, your
already
lordship.
passed?
If your lordship can kindly turn to page 24, para 13 onwards.
24, para 13, yes.
I apologize, your lordship. If I can take your lordship to page, para 2 of the previous page where this honorable court had framed two issues, basically. May I read, your lordship? I have heard the submission of both the rival parties and have perused the documents on record. From the submissions made by the learned counsels for both the parties, the points for consideration are whether or not the settlement order dated so-and-so regarding the boundary of the land within LSCs of the private parties made by the Director, Land Revenue and Settlement, Mizoram, Aizawl is an order made by the Revenue Court under Land Revenue Act 2013. If so, whether the civil court is the appropriate court to decide the instant dispute between the parties, private parties, when there is a designated appellate authority under the Act.
So I think it's part 2, second issue, isn't
Yes, Your
it?
Lordship. Yes,
First
Your
issue,
First issue, there's no problem.
it's no problem. The second one.
Yes, your lordship.
So what is the reasoning?
Yes, Your Lordship. It is seen that the state respondents have clarified with regard to the revenue officers to act as revenue court in terms of Section 77 of the Mizoram Land Revenue Act 2013. The appointment letter of any revenue officer is to be regarded as an authorization letter from the state government for such revenue officers to act as a revenue court, and no other authorization letter order is required for this purpose. Just to recap, Your Lordship, Section 77 specifically stated that a revenue officer who is so authorized. So our adjudication was basically that there has
Not
to be a separate
authorized.
separate authorization letter to act as a revenue court.
So that's also okay, clear.
That is fine.
No,
We are not really
issue.
concerned with that now. We're basically concerned with the second point. In view of the above clarification, it can be safely held that the revenue courts are functioning in the state under the Mizoram Land Revenue Act without the need to authorize the revenue officers to function as such. Section 76 of the Act provides as follows. I'll just skip this since this is a reproduction. And at the last para, since it has been clarified that no separate authorization is required under Section 76 and 77 of the Mizoram Land Revenue Act 2013, the settlement order dated so and so made by the Director Land can be said to be made as a revenue court. It is also seen that though Section 97B provides that the civil courts are not prevented from entertaining suits between private parties for the purpose of establishing any private right, in case it is affected by any entry in any land record. However, in the instant case, it is an admitted fact that the appellant had first approached the revenue court for settlement of their dispute via letter dated so and so, which was heard and considered, and a settlement order dated so and so was made as provided under Section 76 of the Mizoram Land Revenue Act 2013. Thus, considering the fact that the appellant had initially approached the revenue court via a letter dated 7/1/2021, requesting the respondent number 4 to take necessary action to solve their problems, the settlement order dated so and so was made by the respondent number 3, Director, Land Revenue Department, as a revenue court after hearing both the parties. This settlement order being the decision of the revenue court, this court finds that if aggrieved by the settlement order, the appropriate steps to be taken by the appellant was to approach the appellate court, which is the Commissioner Secretary, as per Section 89 of the Mizoram Land Revenue Act. So our humble prayer and what we are trying to impress upon this honorable court is that the second portion was not fully adjudicated upon. Inasmuch as, Your Lordship, during the course of the trial before in the appeal, Your Lordship may kindly turn to page 96, annexure 15 of my review petition. Your Lordship has it? As can be seen from this letter, Your Lordship, this was in reply to a query made by this court via order dated 10/8/2023, as can be seen from the first paragraph. May I read, Your Lordship?
Yes.
Referring to the order dated 10/8/2023 in RFA number 29 of 2023, I am to submit clarification of the query made in the said order as under. May I skip one?
Yes.
One is basically relating to Section 77, which we do not, I think, have a problem with. Now, the second portion of the letter is, as per Section 106 of the Mizoram Land Revenue Act 2013, the civil court is only barred to set aside or modify any order made in respect of land revenue assessment, collection of land revenues or taxes, or imposition of penalty on arrear. As such, there is no bar for civil court to make decision in dispute regarding boundary, possession, and ownership of property. In other words, Your Lordship, my humble interpretation of this communication is that it is in fact the civil court which has authority to decide on the title of any property. The revenue court jurisdiction is limited to all these revenue assessment and collection of land revenue or taxes. This second portion of this communication, in my humble opinion, was inadvertently.
So was that communication mentioned here?
It's part of the record.
14?
It's
No.
part of the records. No, it was mentioned. In fact, it was also reproduced. para 9, which is page 21, para 9 of the judgment and order, as part of the submission of the State Council. And in addition to this, Your Lordship, a further clarification was sought during the pendency of this review petition. Our dilemma was basically to the query that we had placed upon the Revenue Authority regarding whether this at section 97.
Let's see. The Mizoram Land Revenue Act.
So, at section 97, I think this is where the confusion had arisen, Your Lordship, because of this particular mentioning of section 93. Section 97 clearly states that
Okay, nothing in section 93.
This
Because
should-
97, we had said that this refers to nothing in section 93, isn't it?
Yes.
Yes, so
And-
when we say 93,
93 relates to review.
review,
So we
but
had.
there was no review.
So it was not, so this could not have been 93. So this honorable court during the pendency of this review petition had directed the State Council to seek clarification on this, which they have provided.
Wait, no, but in the order of this court, where did you read that?
We did not touch upon this issue, Your Lordship. The order did not touch upon this issue.
But 97, was that mentioned?
It was part of my grounds of appeal, Your Lordship.
Where's the, this thing, order of this court, 97. 97 is mentioned here, that it is also seen that section 97B. I'm reading from page 25,
My Lord.
para 14. Just read that.
It is also seen that though section 97B provides that the civil courts are not prevented from entertaining the suits between the private parties for the purpose of establishing any private right, in case it is affected by any entry in any land record. However, in the instant case, it is an admitted fact that the appellant had first approached the revenue court for settlement of their dispute via the letter dated so and so.
Okay, so when we read section 97, it referred to section 93. Maybe that was the reason.
My lord.
I'm just trying to recollect.
Yes, Your Lordship.
Okay,
So, in fact,
in a review.
the state has clarified by their communication dated 20th of June 2025, wherein they have clearly stated that section 93 referred in section 97 should be read as 96.
What is section 96?
96 is the exclusive jurisdiction of revenue court and bar of jurisdiction of civil courts. May I read, Your Lordship?
Yes, yes.
Section 96 reads as such. Exclusive jurisdiction of revenue courts and bar of jurisdiction of civil
Okay,
courts.
so when you read section 97, nothing in section 96
Yes.
shall be held to prevent the civil courts
Yes.
from, okay.
If that is the case, then the present case, which is basically overlapping of LSCs, will squarely be covered by section 97B. Suits between private parties for the purpose of establishing any private right in case it is affected by any entry in any land record. So it will not take away the jurisdiction of the civil court. That was our humble submission, Your Lordship. So if this 93 is read as 96, I think the whole confusion goes away. And that has been clarified by the concerned department saying that 93 should be read as 96. My learned friend had placed the communication in the last court order on records.
Anyway, that's your submission.
Yes, Your Lordship. The reason why this review is so important, Your Lordship, there are two things. Number one is that when the revenue court themselves have stated that they are not the concerned authority to adjudicate on title and possession, and at the same time, when we say that the civil courts have no jurisdiction, what will happen to the people of Mizoram? We will be left remediless. Number one. The second issue is that if that is the finding of this honorable court, what happens to all those judgments and orders which have been passed prior to this order on issues of title, will they become null and void? It's going to open up a whole lot of Pandora's box. And then when the concerned department themselves are saying that, no, the civil court is the proper court, that is the proper authority. So
Proper
basically,
authority, but previously the act itself does not
bar it.
bars them from taking up the matter.
So, in my humble opinion, there was a slight misinterpretation of that, maybe because of this 93 appearing instead of 96.
Because it's for review only,
Yes, Your Lordship.
previously.
So that is our humble submission,
So
very limited.
then, okay, now you have clarified the state government. So what are you going to do about this? Is there going to be some amendment? Clarification is there, like this. But are they just going to sit with this clarification because the law is as it is? Then they'll have to take steps for amendment of the act. You see, because the act is as it is, that it is only in concerning where the civil courts have the right to entertain, but it's only in matters of review, 93. So whole reading of section 97, not just B, maybe this court has missed mentioning this 93 part because savings of certain suits. '93 does not prevent the civil courts from entertaining the following suits. Anyways, yes. Okay, so this is your clarification, but you don't know whether steps have been taken to amend the act, isn't it? But they have to take then, simply for this case mentioning that would not suffice. Yes. Okay.
Maybe please, Your Lordship. First and foremost, Your Lordship,
Appeal authority, there's a provision to appeal. That's your main case.
Lordship,
Ah.
I'm not denying the fact that the civil court can entertain review matters. But the only issue involved, which remain intact till today, is that, Lordship, whether the civil court can interfere with the decision rendered by the review court, Lordship, that still remain intact, Lordship. So I'm not denying that, yes, the civil court can entertain
Civil
review
courts
matters.
can review,
Boundary
can take
matters.
up.
Any land dispute, title matters, it can entertain, Lordship. However, Lordship, my only point from the very beginning is that, yes, there's a decision rendered by the competent court, revenue court.
So they
Whether
should
the-
go to the appellate authority. That's your
Lordship,
main
Lordship,
thing.
That's my point. And Lordship, before that, Lordship, first of all, I'd like to submit that we should not exceed the very limited scope of review, Lordship. Because, Your Lordship, Order 7, Rule 1, CPC talks that there are 3 subjects in which review may lie. One is, Your Lordship, discovery of new and material importance, Lordship. New evidence, new material, Lordship. And the second thing is that, the Lordship, error apparent on the face of the record, Lordship. And the third one is any other sufficient reason. So, Lordship, as per the decision rendered by the apex court, the third subject, sufficient reason, is to be equated with the previous subjects, like error apparent on the face of the record. So, Lordship, in my understanding, from careful consideration of the submissions made by my learned friend, as well as from perusal of the review petition itself, Your Lordship, there is totally no reason for coming before this honorable court by way of review, Your Lordship. This is not an appeal, Your Lordship. So, in a review, the review petitioner is prohibited from raising any question which was already decided by the previous court. The mere possibility of 2 views, Your Lordship, does not invoke the power of a review, Lordship. And in this case, Your Lordship, My learned friend now strays upon the 97 section, 93, 96, Lordship. So, Your Lordship, on perusal of the grounds set forth in the review petition, which start from page number 11, Your Lordship, there's nowhere mentioning about the clerical mistake or any inadvertent commission of error. 97, 96, 93, Lordship.
So which came out later.
Lordship. Nothing is mentioned in the ground set forth by the petitioner, Lordship. And even that, Your Lordship, even presuming the particular section 97, 93, 96 is to be admitted, Your Lordship, even presuming, that doesn't make sense about this particular subject. Because the
It
review...
is an appeal
Yes,
against the
that's
judgment.
appeal, Lordship.
huh?
Exactly, Your Lordship.
So that's why clarity is required. Now he's saying all the other cases, previous orders, a person can approach the civil court.
Lordship.
Okay, as per the clarification made now, can approach the civil court. But in the instant case, it is an appeal against the decision of a revenue court.
Exactly,
When
Lordship.
appellate authority is made. Clarify on that.
No, my lord. This is an appeal against order passed by the trial court.
By the trial
Trial
court, where the trial court says, but the trial court says that when there's an appellate authority, is it? Let's see
Yes,
the trial
exactly,
court.
Lordship. That is the matter.
Why was it, why was it not considered by the trial court? What is the order? Was that the reasoning? Let's see, let's come back.
Yes, Your Lordship. Page 65,
65?
Annexure
Yes.
9.
What is the last part of the, so you had approached this court on appeal?
I apologize. Page 71, Annexure 11.
71.
Yes.
It's concerned whether the civil court is the proper appellate authority to consider the appeal against the order.
Their
I think that's
trial-
something like that.
Yes, page, it starts from 71. Relevant paragraph is at page 75, para 6.
Yes.
May I read, Your Lordship? After thoughtful consideration of the reliefs claimed and on considering section 9 of the CPC 1908, order 14, rule 2, subsection 2, section 76, 89, 90 and 96 of the Mizoram Land Revenue Act 2013, it is considered that as being aggrieved with the settlement order dated January so and so passed by the revenue court, the plaintiff herein should have approached the proper forum. They're saying that I am not the proper forum by virtue of section 96. That is the exclusive jurisdiction of the revenue court. In other words, the imputation is that I don't have jurisdiction because section 96 is the exclusive jurisdiction of
89, provided under section 89. 89 is the appellate authority.
appellate authority.
Ah.
76 is revenue officers and revenue courts. So, and 96.
What's 96?
96
Let's come
is
back
the-
to 96.
Exclusive jurisdiction of revenue court. In other words, the trial court is saying that it does not have the jurisdiction. It is not the proper forum. In our submission was that 97 should also have been read along with 96.
See, basically the issue here is
Jurisdiction.
when you want to appeal against an order which we have already decided is the revenue court, do they appeal against the order of the revenue court to the civil court or to the appellate authority given under section 89(3)? So this is only concerning the appeal.
My humble interpretation, Your Lordship, is that there is no reason why it can go both ways. Because by virtue of 97B,
So they can approach both the courts,
correct,
revenue court or the civil court. Okay.
And-
If they are unhappy with the boundary, whatever, they can
Right.
approach both the courts. But in this case, what has happened was they had first approached the revenue court. and the revenue court passed an order which they are unhappy with, and then they had gone on appeal. When they went on appeal, they filed it before the civil court instead of the appellate authority. I think that's the case here.
Instead of filing the appeal before the appellate authority in the revenue court, we approached the civil court. That was the situation. So in any event, Your Lordship, since one small submission, Your Lordship, since the issue of jurisdiction is also part of this subject matter, our submission is that the trial court, one of the grounds for dismissing my suit was Section 96.
Okay.
Section 96 was one of the reasons why it was dismissed, saying that I am not the proper forum. The trial court is not the proper forum. During the pendency of the appeal, the concerned department, revenue department themselves have stated that the jurisdiction of the revenue court is confined to assessment of tax, collection, if there is any dispute regarding collection of taxes, so and so. It has nothing to do, and they did not speak anything on title and possession. Now, if we use the
So you're saying
principles
that
of
the revenue court, in passing the impugned order, had gone beyond its jurisdiction?
also that going by their own
Is it?
clarification, going by their own clarification,
At that time, let's see, this thing,
the
during the
clarification.
review, during the appeal, was that one of your grounds?
Yes, Your Lordship.
So you're saying that under 96, the jurisdiction of the revenue courts is confined to these matters, isn't it?
As per their clarification, and also
96, as per 96, it's confided to this.
yes,
But here F is distribution of land or allotment of land revenue. F,
basically it's the area of the land.
okay. So, okay,
sorry.
no, I'm getting just, okay, so your point is that the revenue court had no jurisdiction to consider the matter between the parties. And so you had approached the civil court.
So, and one of my
Not as an appeal.
one of my main grounds of appeal, which can be found at page 85, was that Section 96 should not have been read in isolation of Section 97. This I have
Okay.
pointed out at my ground number 2.
This is the
Sorry, ground number
Appeal.
3.
appeal application.
Yes.
Your appeal.
So this issue was also raised by me at ground number 3. For that, the learned trial court erred in law and in fact while passing its order dated so and so, inasmuch as one of the grounds for dismissing the civil suit so and so is that the jurisdiction of the civil court is barred by Section 96 of the Act so far as the subject matter of the civil suit is concerned. It is not denied that jurisdiction of a civil court is barred by Section 96 in respect of certain subject matter, the jurisdiction of which is exclusively given to the revenue court. However, perusal of Section 97 would go on to show that the civil courts have been given jurisdiction in respect of certain subject matter. And at the bottom, I've mentioned Section 97B as well.
Okay, leave it as it is, okay? So supposing the revenue court had exceeded its jurisdiction and tried matter where it doesn't have the jurisdiction, then you can't you still go on appeal against the revenue court saying that it doesn't have the jurisdiction and appeal to the appropriate authority?
I agree with that. But that does not take away the jurisdiction of the civil court, because this is how it is being interpreted, this judgment and order passed in the appeal as well as the order of the trial court. Because this particular judgment is being used time and again before the civil court nowadays, trying to take away the... That's why some
But it is
clarity
only
needs to be...
It's only considering the appeal. It is not the jurisdiction of the court as such. It is whether there's an order passed by the revenue court.
But there
So
has to-
when there's an appellate authority, they should go to the appellate authority.
That is fine. In my humble opinion, Your Lordship, I beg to differ on that. If we apply the principles of harmonious construction, if we harmoniously construct and interpret these entire provisions, my humble submission is that yes, appeal can be filed before the appellate authority of the revenue court, but that in itself will not take away the jurisdiction of the civil court. by virtue of section 97B.
So when you approached the civil court, you were the one who had approached the civil court, is it?
Correct.
It was against the order dated 17 something?
Of the revenue. Because it relates to entry in my passes. And by virtue of 97B,
So the civil court,
will
we
have
have to see,
jurisdiction.
we have to see, can it act as an appellate authority then? Against an order passed by the, that you have to see. So, because then this, the civil court as its original jurisdiction can try these matters, no doubt. So how do you interpret that? First appeal, second appeal is there. So as a original jurisdiction, it can try those cases, okay, not covered. But those cases which are not covered by section 96, it can take up those cases.
It's a
But now this court, revenue court, had taken up a matter which is not within section 96,
Madam,
beyond,
I
isn't
think that
it?
we're pointing more towards the doctrine of eclipse, where one has to choose a certain path. Like, for example, under the Motor Vehicles Act, it is specifically provided that you can file either under the Motor Vehicles Act or under the Employees Compensation Act, but not both.
On appeal.
Not both. So, however, the legislature in their wisdom have not included such doctrine of eclipse in this provision, thereby giving the
I'm still, anyway, yes, please continue.
yes, thereby it would still be open to the party to either go to civil, to either approach the civil court or approach the revenue authority, even if it's appellate authority. Because it was not exactly a case where I filed a complaint or anything like that. There was a dispute between myself and the respondent, and then I filed a communication just to verify my land. So, will that amount to a revenue court being approached or not? It was just a piece of paper.
So you're still saying that the decision is not a revenue court, the decision that
In a way,
impugned-
but then I'm not stressing on that. If your lordship says that we should approach the appellate court, no problem, we will do that. But the only thing, the only reservation I have is that by virtue of this judgment and order, it's giving this implication that the civil courts have no jurisdiction to try title matters.
No.
But the revenue court, on the one hand, they're saying that no, we are not the concerned authority.
That's not what the judgment is about. The judgment
Unfortunately, that is
basically,
that is
maybe
the-
we can make some clarification, because the judgment is basically who is the appellate authority. If the matter was decided by the revenue court, then there's a provision to approach the appellate authority. So it goes to the appellate authority. Now the civil courts has the original jurisdiction to decide cases which are not within section 96, is it? 96 is the exclusive jurisdiction
Correct,
of. So in this case also, it appears that the revenue court had acted beyond its jurisdiction by deciding a dispute regarding title, which should actually be placed before the civil court. So if they are unhappy with that order, it is the appellate authority who should say that they don't have the jurisdiction and they should approach the civil court. Then the civil court can try the matter.
But 97 does not say anything about original or appeal.
It doesn't say anything, but the act itself, the revenue, this act, the Revenue Act, mentions about an appellate authority, isn't it? So it doesn't, 97 does not mention anything about whether it's an appellate authority or not, isn't it? But in your case, the revenue court had made a decision. And the revenue court appears to have acted beyond its jurisdiction because it is not within those matters of 96 exclusive jurisdiction.
Correct, Your Lordship.
So maybe this order, we can make a certain clarification based on the clarification made by the Revenue Department. The Revenue Department will have to make an amendment. This is not enough.
Otherwise, Your Lordship, if
Otherwise, this confusion will continue. Only for this case, it's clear.
there was a similar situation in Assam in 2002, which the judgment I've relied upon
Yes,
previously
yes.
also, that Thandalal case or whatever. So, in light of that, Your Lordship, if Your Lordship may give, if you
Yes,
can
I'll
kindly
have
give me
a
some.
look at again.
Your
I got
Lordship-
your point.
Your Lordship may kindly give me some time. I will go through the Revenue Act of Assam and see some similarities, because I'm sure that even our Revenue Act is somewhat based on the Assam Act. So if I may be given some time, and then by the next court date, I will try and come up with this clarification.
Okay, because there should be clarity. I'm
Because-
not against that. Here, the order 17 is liable to be set aside.
On-
It appears, because it has
On the
gone
record, Your Lordship.
beyond its jurisdiction. It appears 96.
On the record, I would like to stress that we are not against filing the appeal. It's just that the implication of this
Yes.
is very.
So we'll see whether maybe the wordings of the judgment is not clear enough so that it is read in such a way that it appears that the civil court doesn't have the jurisdiction. Then that should be avoided. I agree with that, isn't it? So we'll fix it for further hearing.
Lordship, if I may, I'd like to take some more, a few minutes, Lordship. Because, Your Lordship, as I said before, this is a review petition, not an appeal, Lordship. So we have to confine only the review scope, Your Lordship.
But
So the
review
only thing
scope
we
is
submitted
there,
by
review
violence-
scope is there. Scope for review is there because some clarification has been made, even though maybe he had not mentioned in his, first petition regarding this clarification that should be sought. But it has come up during the proceedings that some clarification. Now with that clarification, maybe we'll have to see. So you come prepared,
Your Lordship-
more prepared.
Lordship, 5 minutes only, Your Lordship. Even that, Your Lordship, that clarification, section 96, in section 97, 96, 93, Lordship, that clarification, whatever clarification may be, that doesn't make sense about this particular review petition, Lordship. Because, Your Lordship, to that particular point which my learned friend raised regarding the jurisdiction of civil court, Your Lordship, I'm not objecting that the civil court has no jurisdiction, the civil
have-
jurisdiction,
they have,
Lordship. It has original jurisdiction. If I have boundary dispute, Lordship, let's take an example. If I have boundary dispute, there are two forums. One is approaching the revenue court. As per section 76, revenue officials has revenue court, Lordship. And I also alternate remedies, approaching the civil court. So Lordship, if once I approach the revenue court by submitting a complaint, actually, Lordship, in this case, the complaint was originally submitted by her, Lordship, in the
By-
revenue court. By her,
you.
by review petitioner.
To the revenue court.
Yes. Lordship, if a complaint was submitted, that is dealt by the revenue court. And the revenue court is governed by the appeal provision 2013 Act. If he is not happy with the decision, he could not simply challenge a particular order before the civil court. Like that, Your Lordship, if I approach the civil court, Lordship,
No, I'm getting your point. So the main issue here will be with this clarification made, okay, whether the civil court can act as an appellate court and cancel the order made by the revenue court.
Lordship,
Come
the
up-
Act is
come
very
with-
clear.
So
The Act is
he's
very clear.
praying for time, we'll give him
So
time.
for that, Your Lordship, may I
Let's
kindly
see.
take with section 11 of CPC? Still, Lordship, I'll finish by
Okay,
5 minutes only,
yes.
Lordship. Section 11 CPC. I like to read out, even though it's a very
Okay.
familiar provision, Lordship. Section 11.
Ah,
I'll try to
Yes,
finish by 5
indicator.
minutes, Your Lordship. 11, I'm reading, Lordship.
yes, please read.
No court, it's a no court, shall try any suit or issue in which the matter
11.
directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit. Lawsuit. The wording is that competent to try the suit. So the revenue court itself was also competent. So nowhere in the previous appeal or in this particular petition, they did not mention about the incompetency of revenue court in adjudicating that matter, lawsuit. So they admitted the fact that yes, the revenue court was competent in doing such matter. So they cannot simply
Even
challenge
if it
the
was
order,
not competent, and had passed an order, and if they go against and they're unhappy with the order, they should go approach the appellate court
Yes, that's exactly lordship.
jurisdiction.
If I'm happy with, if I'm not happy
That's
with
how
the
it
orders to the
appears,
court.
black and white. But let's see what do you have to say? But there's a judgment of this court, coordinate bench of this court, which deals with the Assam Revenue Act, isn't it?
Yes.
So he's saying that the principles applied in the coordinate court, which he had cited, are the same in this case. So let's see. We'll have a look at that judgment again properly.
But your lordship, please
Because
don't
if,
forget
if,
about
if,
the
the,
review
if,
stop.
if this issue was
It's
already
not an issue,
decided,
Yeah,
if this issue was already decided, same issue by a coordinate bench, which he's saying it has been, and if this court happens to differ with the findings, then it would have to give refer it to the same different the DB.
larger bench.
So we'll see. He's saying that the judgment which I referred to is exactly the same as the instant case. So let him come up with that point. But then again, it will be a matter of per incurium. And if I have wrongly interpreted the judgment which we are serving, then it's again for the DB to decide, not as an this thing.
I'll try my best to clarify.
So whether it's a matter of per incurium, that has to be seen.
I'll
also.
try my best to.
So come up now. Anyways, heard Mr. Lalfa Koma, learned counsel for the petitioner. Also heard Mr. T. Lalunsiam, learned counsel for the respondent number one, and Ms. Caroline K. Lungoipui, learned government advocate for the state respondents. Have you heard the submissions made by the learned counsels for both the parties? This is matter again on, want a fixed date? On?
After vacation, Your Lordship.
After vacation,
Any date, when both of you are available, that I want.
Anytime after vacation. I'll leave it to my friends.
maybe 15 lordship.
Too many cases fixed on 15th. We won't have the time.
Learned friend is not,
On,
17 lordship.
okay, this is matter on 17/7/2025 for further hearing. Yes.
I'm deeply obliged, Your Lordship.
For orders, item 6.
I would like to tender my sincere apologies for not making on time. It's because I was given the wrong cost list. Your Lordship, in the last court date,
Case diary would be necessary.
case diary was called for, but then when we contacted the prosecution, it seems that charge sheet has already been filed. So direction may be made to the registry to call for a scanned copy of
Scanned
the...
copies will be required.
Yes.
Copies of the charge sheet.
Heard Mr. Sizoram Chana, learned counsel for the applicants, along with Mrs. Mary L. Kiante, learned additional PP for the state respondents. It is submitted by the additional PP that though this court, in its order dated 24/06/2025, had called for the case diary, which, however, she submits that charge sheet has been filed in the instant case. In view of the above, this court find it appropriate to call for the scanned copies of the charge sheets / CR, case record, okay, and TCR. List the matter
14.
on 14. So many cases have been fixed. Make it 15th.
Milo.
I don't think many cases have been.
15.
Yes, okay, list the matter on 15/7/2025.
Obliged, Your Lord.
Hearing list, item 5.
Yes. Who's the counsel for the,
Mr. Sizoram Chana, my lord.
he is here.
Oh,
On the last
okay.
occasion, he has to take instruction on the MRB.
What was it about?
It was whether the chairman, as an appellate
Oh,
authority,
yes, same.
was included.
Here, my lord, is,
For further hearing, we'll continue. Learned Counsel has prayed for time to get clarification, constitution of the appellate authority, huh? So could you get some clarification whether the, disciplinary authority is also the chairman of the appellate authority? I think that's a clarification required, isn't it?
regarding that, my lord, I have the regulation, my lord. Regulation itself says that regulation 50, my lord.
What
That-
regulation? Where?
On the last occasion,
We
my lord,
have a copy?
I have given to your lordship.
I have also have a spare
It may
copy
be.
also.
Oh, yes.
Regulation 49, lordship, talks about right to appeal, my lord. Then thereafter, right below there, my lord, regulation 50 says that appellate authority, an appeal shall lie, number one, the court where the chairman is the competent authority. Number two, the chairman where any other officer is the competent authority, my lord. So now in our case, the chairman, my lord, is the DA, disciplinary authority. That means the appellate authority will be the board of directors. And for that, my lord, the constitution I have got in the RRB Act. This is a central act, lordship. And this covers all the regional rural banks, including the resident respondent rural bank of Mizoram, lordship. So therein, my lord, section 9 is the constitution. Chapter 3, under the heading management, section 9, my lord. Board of directors, lordship. If I may, kind,
Yes.
lordship, kind permission. The board of directors shall consist of the chairman appointed under subsection 1 of section 11 and the following other members, namely, number A, 2 directors who are not officers of the central government, state government, reserve bank, national bank, sponsor bank, or any other bank to be nominated by the central government. Then I'll skip the proviso also. Number B, 1 director who is an officer of the reserve bank to be nominated by the bank. Number C, 1 director who is an officer of the national bank to be nominated by the bank. Number D, 2 directors who are officers of the sponsor bank. The sponsor bank, my lord, herein means the State Bank of India, SBI. And number E, lordship, 2 directors who are officers of the concerned state government to be nominated by the government. So, as of now, my lord, as per information received by me, my lord, we presently have 7 members of the board of directors right now.
Okay, 7 members.
7 members. Out of which only the chairman, who is also chairman of the MRB, is the one coming from the respondent bank. And the rest are all from outside, as constituted by this section, section of the Rural Bank Laws Act. That means out of 7, even though there are 7, even though the chairman himself is also presiding over the meeting of the board of directors, actually there are 6 others who are not members of the MRB lordship. Actually, they are from outside, my lord. As it is spelled out here in my lord in this section, 2 officers of the state government, 2
directors of the SBI, one director from National Bank, means my lord, NABARD herein, in respect of MRB, NABARD, and one representative from Reserve Bank of India. So actually, even though he himself in name is chairman, all the decisions are taken by all those members who are from outside Mizoram Rural Bank. So actually, he, as we are very afraid that he might be having some influence. That didn't happen, my lord. So actually, and for that, my lord, if I may take a lordship to section 14, my lord, of the
Of which
same
one?
act. Same
Regional Rural Banks
My-
Act.
Section 14 talks about meeting of the board, my lord.
Yes.
The board of directors of a regional rural bank shall meet at such time and place and shall observe such rules of procedure in regard to transaction of business as at its meeting as may be prescribed. Number 2, the chairman of the RRB shall preside over every meeting of the board, and in his absence, such other director as the chairman may generally or in relation to any particular meeting authorized in his behalf shall preside, and in the absence of both chairman and directors, so authorized directors present at the meeting shall also elect one of them to preside over the meeting. My lord, what I'd like to stress on is the subsection 3, my lord, below there. All questions at the meeting of the board shall be decided by majority of the votes of the directors present and voting, and in case of equality of votes, the person presiding shall have a second casting vote. That is how decision is taken in the board of director meeting, man. That means actually, even though the chairman of the MRB is presiding the meeting, he has no influence. So they are all 6 others are there, cannot be influenced. Who actually they are from the
So you're saying
sponsor
even
group
if though
above
he
them.
was the discipline authority,
Minor.
it is the decision of the board, not his alone.
Minor.
Isn't it? Appellate authority. Okay, that's your point.
Yes. So now coming to our present case also. Right from, I'd like to bring a lordship quickly through the proceedings undertaken therein, my lord, in the disciplinary proceeding, lordship. They themselves in the petitioner herein in her petition and pleadings herein, my lord, admitted, my lord, to the allegation leveled against her. If I may take lordship to page 32, my lord. 32 is the type copy of Annexure 2. Before that, my lord, Annexure 1, my lord. Annexure 1 is at page 28 of the petition, and 29 is the type copy. This, lordship, is the first letter to the petitioner, my lord, issued by the respondent bank, saying that they coming to know of the irregularities. They issued this preliminary letter to the petitioner, my lord. And herein at paragraph number 3, my lord, they stated that please therefore submit your explanation.
Wait, where are you reading from?
Page 28.
Of your affidavit in opposition?
No, my
What?
lord, the petition.
Of your, the petition, page 28. Then, wait. 28,
Yes, 20,
Oh,
actually 29,
okay.
the type
page
copy. my lord.
29.
29 is the type copy. It's easier,
Yes,
it's more legible.
okay.
Down there at the bottom of the page, lordship. After informing her, the petitioner, that there are irregularities and those allegations in which she had acted in transferring certain amounts. Actually, the amount she had authorized transfer herein is more than 12 crores, Your Lordship. The whole amount she had transferred herein is 12 crores, 12 lakhs, 23,041 and paise 61, madam. So it's quite a good, big number, Lordship. And out of which, Lordship, 63 lakhs, 63,778 was misappropriated, my lord. Everything was clearly explained to her,
So
saying
no, you had transferred the said amount to Mr. Interbank Deposit.
my lord.
So isn't this an interbank deposit? So it goes to the bank, same bank at Siha.
That, my
Saya.
lord, yes, the paragraph talks, speaks clearly about it. Sir. And if we go down there, though the amount was not transferred of provision, others account number so and so earlier on, and subsequently misappropriated the amount in different accounts.
Okay.
That 63 lakhs and 63,778 was later misappropriated, my lord. The whole transaction was 12 crores, Lordship. Out of that 12 crores, 12 lakhs, 63, more than 63 was misappropriated.
And then subsequently misappropriated. Okay.
Misappropriated in different accounts. Because the petitioner transferred it, man. So they explained everything to her. And they told her to submit her explanation to the said allegation. And whether and as to why disciplinary proceedings shall not be initiated against her, madam. That was there in this page number 29, madam. And in reply to that, my lord, she had filed page number 30. This is so course, my lord. And the type copy is 32, my lord, page 32. And page 32, lordship, at paragraph number 3, my lord. If I may read it, Lordship. On that fateful day of 14 January 2019, around 4 p.m. in the afternoon, even though I was an officer in charge of fixed assets, my lord, please kindly mark this one. She was an officer in charge of fixed assets. She knew it very clearly, my lord. She was not in charge of any other duty, only fixed asset, and not of accounts branch, man. Only fixed asset. I was requested by Mr. Zosang Puya to authorize a trickle fee transaction totaling 12 crores, 12 lakhs, 23,041 rupees, 60 paise for reconciliation of several amounts with so and so, so and so. Since I was the only officer available at the time, I asked Mr. Zosang Puya if everything was in order, and he replied affirmatively. After taking a quick glance at the transactions and finding that the credit debit transaction tallied, I had authorized the transaction. This is an admission, my lord. Admission of the allegation leveled against her. Despite not being in charge of the account section, my lord. She had authorized the transaction of 12 crores, my lord, out of which 63 was later misappropriated because of her transfer. And that is page number 33, the next page. At paragraph, she said that I deep and truly regret that my action has caused grief to my colleagues in the bank. I heard so
She's admitted, that's what
she
you're
admitted,
saying.
actually. And the reason for doing that may be different, man. But the truth remains is that she acted and she admitted, man. So, page 34, man, is the office order that was issued on 7/9/2018, saying that Mr. Zosang Puya has been entrusted the entire responsibility of account section, with a special focus on unreconciled entries in BGL, suspense and cash. He will be working under the supervision, guidance, control of senior manager accounts. So even her senior colleague, Mr. Zhou Sangpuya, who was entrusted, will have to work under the guidance of a senior manager. That was the sensitivity of account section, my lord, in a bank. So even when this Zhou Sangpuya was entrusted, my lord, he has to work under the supervision of a senior manager of accounts. So there is actually no question of doing all these fund transaction in the account section by someone else who is not totally entrusted, man. So even the one who is entrusted will have to work under the supervision of a senior manager. And page number 35, Lordship, is the affidavit executed by the Zhou Sangpuya, who was put in charge of the account section. Lordship. My learned friend had also referred to this also earlier. And this speaks clearly about what was done. And the only thing now this affidavit tried to say is that the petitioner did not do it with evil motive. That's all, man. But it is admitted that she had done it, and that resulted in subsequent misappropriation of 63 lakhs. 36 is the type copy, and 37 is the charge sheet. This is very important. What is he charged of? What is he alleged to have done? Which is also to result in imposition of the penalty. Then everything is spelled out herein as earlier. It's only transaction done, which is not entrusted to her. And at paragraph number 3, my lord, it is stated that this is a normal practice. Ms. Judy Lalomzuali is informed that the inquiry, if necessary, will be held only in respect of articles of church that are not admitted. Actually, usually, Lordship, even in criminal trial also, madam, admission, on mere admission, penalty can also be given, madam. And here also, my lord, that clause is given clearly to the petitioner, saying that the necessary D will be drawn only in respect of those which she did not admit. Actually, she admitted the substance of allegation. And here also page 39 is the type copy, Lordship.
Yes.
Here also in the second paragraph, Lordship. Due to her gross negligence and dereliction of duty with malified intention, on so and so, she had authorized and transferred 12 crores, 12 lakhs, 23,041 rupees, 61 paise from head office provision account bank so and so to the 25 different IBD accounts branches HO to 25 different IBD accounts of branches as reversal of fund for reconciliation, which were transferred to the provision other account on so and so, out of which she transferred 63 lakhs 63,778 rupees from a head office provision to so and so, and for misappropriation embezzlement. This is the charge. This is the charge leveled against her. 41 is accordingly the imputation based on the charge. Imputation is that she has transferred. So what I mean, Lordship, with all these things, that if we go through all the imputation and charge level against her, it is, we are not talking about any motive. Motive is a different thing, actually, in departmental proceeding. So she had done is very clear. And
So
she
you say
herself
she's admitted, huh?
Yes, Lordship. So, and that also she reiterated at page 41 in her written statement of defense also.
Yes.
She cannot look back what she had already stated in her earlier reply made to the bank, my lord. Paragraph 3 also here in my lord. And number 2 also. And page 42 also, my lord. 42, my lord. This is one material portion is there in the first paragraph, your lordship. That is a continuation from the earlier page, your lordship. An office order number so and so, dated so and so, was issued where Mr. Zhou Sangpuya was put in charge of resolving unreconciled transactions under the supervision of senior manager accounts and general manager. As I was one of the incumbent officers in the head office at that time, I had read, acknowledged the said office order, putting my initial on it, my lord. She admitted of taking note of all these office order, which is saying that she is not the one authorized to do transaction. Only Zhou Sangpuya, lordship, was the authorized person to do the account section transaction. So despite all this, lordship, she had done the transaction. And herein at just below the fourth paragraph, lordship, towards the middle and the last, she said that in the last, towards that paragraph, towards the end, lordship, I had authorized the transaction for the sake of smooth functioning of duties. I had done nothing wrong in the said authorization. As such, Mr. Zhou Sangpuya also stated facts constituting said transactions by affidavit so and so, so and so, so and so. So these are all admission, in lordship. And here also admission, in lordship. And even in proceedings of departmental inquiry on charge sheet also at page 48 and excerpt 7, she also admitted, madam. And she says she will not be having any witness also, madam. And now if I may take lordship to the disciplinary authorities order, lordship, page 50. 50. Here, the DA, the disciplinary authority, is recording his reason for his finding, lordship. Reason for findings, lordship.
So the inquiry officer says not proved.
Not proved, yes, but not since the DA disagree with the finding, lordship. The disciplinary authority is making his separate finding here on this page, lordship, because he is authorized to have done that, my lord, as being a DA. So if I may read, lordship, the comment section.
I think we have read it. It was already read before.
Oh, my lord, my lord. So she had admitted, she has authorized the Trafalgar transaction. Evidences available on record also prove the same. The charge officer has not been entrusted with the work of account section according to the referred office order related to allocation of tasks to Ms. Zhou Sangpuya. At the material time, the charge officer was dealing with fixed asset under so and so. Still, she has authorized the fraudulent transaction leading to pecuniary loss to the bank. All these are the reasons recorded by the DA. And since that was there, and now at page 52, again, as she was given a chance, she now replied to the DA comment, my lord. This is DA comment. And after that, my lord, proposed
Then
penalty.
the penalty.
54 is the so-called notice in connection with proposed penalty. So proposed penalty, and she has been given a chance to show cause as to why penalty of so and so shall not be given to her, to which page 56, lordship. She filed her reply to the proposed penalty. And after all these proceedings have been done, lordship, after giving her all the chances, lordship, despite her right from the beginning admitting to the allegation, my lord. Still, the departmental proceeding was done duly in accordance with law, my lord. And now, page 57 is the final order. And everything detailed, justified, lordship. And page 61 is the operative portion. Reduction, the penalty imposed on her was reduction to 2 stages, lowering time scale of pay to 2 years. The official shall not so and so and so and so much. So against that, my lord, stay as provided under section regulation 49 of the MRB regulation, she has filed, my lord, her appeal, which is at page 62, lords. And herein again also, she again admitted to the allegation level against her in the charge sheet and also in the imputation also, which can be read from page 64, internal page 4, lords, of the appeal letter, lords. Page 65 under paragraph 11A, lordship. Towards in the middle, in fact, as I had read and acknowledged the office order date number 12 dated 7/9/2018 issued by the head office by which Mr. Josang Puya was put in charge of resolving the unreconciled transactions under the supervision of senior manager accounts and general manager, and since there was a big push to eliminate all unreconciled entries in transactions, especially BCG accounts and intrabank deposit accounts from the month of so and so, I did not have any doubt against Mr. Jones when he requested me to give authorization as stated above. In this regard, I beg to state that I had authorized the transaction solely in good
So
faith.
she admitted, anyways, so then,
So
the appeal was, this thing not allowed,
yes,
isn't it?
the board of directors, my lord, duly constituted under the RRB Act,
Yes.
also dismissed her appeal, my lord. And they resolved to uphold the decision of the DA, lordship. So now, my lord, with all these chances duly given, natural, the principle of natural justice, my lord, having been duly followed, my lord. So in that case, my lord, I'd like to refer to certain judgment from the apex court, lordship.
Yes. First authority.
My lord, please kindly bear with me, lordship. Nineteen 1999, volume 1, SEC, lordship. 759.
Para.
16, lordship. Sixteen onwards, lordship. If I may read, lordship. The High Court appears to have overlooked the settled proposition that in departmental proceeding, the disciplinary authority is the sole judge of facts. And in case an appeal, that means statutory appeal, lordship. Appeal is presented to the appellate authority. The appellate authority has also the power, jurisdiction to reappreciate evidence and come to its own conclusion on facts, being the sole fact-finding authorities. Once findings of fact based on the preparation of evidence and are recorded, the High Court in jurisdiction may not normally interfere with those factual findings unless it finds that the recorded findings were based either on no evidence or that the findings were wholly perverse or legally untenable. I'll pause here for a moment, lordship. Now, in the present case, now we have the admission from the petitioner herself, and besides that, madam, about more than that, now we have all the evidences that she had actually done it. She had actually authorized the transaction which she was not authorized to do, madam. and which was later resulting into the misappropriation of an amount of more than 63 lakhs of rupees being misappropriated, Lordship. I'll continue reading, Lordship. The inadequacy or adequacy of evidence is not permitted to be canvassed before the High Court. So, Your Lordship, now when Your Lordship take up this kind of matter, Lordship, the adequacy or inadequacy of evidence recorded cannot be entered into, Lordship, since here as a writ court, my Lord, we are not sitting in appeal, Lordship. We are only looking into the process, looking into how the DE has been conducted. Was any chance of explanation, hearing was afforded to the petitioner, has to be looked into, my Lord. So whether evidence is inadequate cannot be questioned before the High Court. Since the High Court does not sit as an appellate authority over the factual findings recorded during the departmental proceedings, while exercising the power of judicial review, the High Court cannot, normally speaking, substitute its own conclusion with regard to the guilt of the delinquent.
Many cases, no, the procedural lapses what has to be looked into. Isn't it fair
only that
chance of
much,
being heard? Huh?
not on the factual
Any other
question.
judgments concerning that?
Yes.
One or two is enough. You don't have to give many. No?
Yes, also. Down there also, it's a very enlightening, perhaps 17, 18, 19 also. So, and now, if I may take Your Lordship to another citation, Lordship. We are now not sitting in appeal before over the findings on facts, Lordship. Regarding the penalty, Lordship. Whether the penalty imposed is adequate or not, or is in conformity with the allegation, if I may take Lordship to (2022), Lordship, Volume 1 SCC 373. Paragraph 23, Lordship. If I may read, Lordship.
Yes.
The well-ingrained principle of law is that it is the disciplinary authority or the appellate authority in appeal which is to decide the nature of punishment to be given to the delinquent employee. Keeping in view the seriousness of the misconduct committed by such an employee, it is not open for the courts to assume and usurp the function of the disciplinary authority. So we, my Lord, seems to be have to leave it to the disciplinary authority or the appellate authority regarding the amount of and degree of penalty to be imposed. So
only when it is shockingly disappropriate.
yes, and that too
Proportionate, isn't it?
Yes,
Yes.
it is shocking to the conscience of the court. And that too, it has to be returned for giving a fresh penalty, not directly to be modified by the court. That is how, as your Lordship knows very well regarding that issue also, my Lord. So even though I have some other citation, I think that will suffice, my Lord. So since now everything is done in due order, my Lord, during the proceeding, and since the Board of Directors was duly considered as per the provision of this RRB Act, my Lord.
See, only thing is the disciplinary authority had signed, and then here it says chairman disciplinary authority. Now the appellate court chief manager, within
is-
brackets P and AO. Chief manager and the discipline authority is also the manager, chairman.
No, my Lord.
Okay, chairman is also the Chief manager, is it?
No, my
This
lord. Chief
signature?
manager is only the conveying,
Okay,
officer,
conveying
my lord.
person.
Only
Okay,
conveying
okay, okay.
officer.
Not a member of the board.
my lord.
Oh,
He's only
okay.
conveying the decision of the appellate authority.
Okay, appellate authority. Okay, fine.
My lord.
Yes.
My Lord, if I'm allowed to rebut on the few points. Firstly, Your Lordship, regarding the same individual in respect of the disciplinary authority as the board, one of the board members, my Lord, I will not make much submission in this regard, but with apologies, my Lord, I would like to rely upon one High Court, Allahabad High Court judgment. And if I'm allowed to hand it over the judgment copy to the bench assistant, Your Lordship, after
okay.
the hearing also.
Uh-huh.
Then this is 2024 SCC online, Allahabad 6790, which says in para 15 that, Your Lordship. My Lord, I'm allowed to read this one, please. It says, in all the three stages of the requirement of law is that inquiry officer has to be different person than the disciplinary authority, and appellate authority has to be superior authority who looks into the correctness of the order passed by the disciplinary authority. And more particularly, in the subsequent para, it is stated like this. My Lord, I'll just highlight the paragraph also. It says that in these three stages, those persons who are the authorities should be different person, my Lord. That means, and I will be relying upon the Madras High Court as well, which says that it is one of the, let me at least say the citation, my Lord. This 2009 Supreme Madras 1787. And here it is regarding one Chennai
You
Cooperative
didn't give
Society.
the citations
Yes.
beforehand or what? Have you given? No.
Not yet. So, with apologies, my Lord, I'll
Oh,
give
you
it
should.
to him later.
Oh.
So I'll just highlight the para also, the relevant para. And in that particular case, Madras High Court also in this matter, one of the employees, which is similar to the present matter, my Lord, he was imposed a penalty by the disciplinary authority. And when appeal was filed, disciplinary authority was one of the board members. And Madras High Court had set aside the decision,
So similar.
saying that, yes, saying that he could not be one of the board members. So, my Lord, this is the reason why I'm raising this point regarding the, and admittedly what my learned friend has just said is that he's one of the, being the chairman. And it can happen like after going through the particular section of this MRB so-and-so act, and he can appoint, the chairman can appoint any one of the board members to preside over the meeting. Then that wasn't done so, my Lord. So it is very biased. So there is the procedural lapse which can be seen clearly. And another point is that, my Lord, let me recap shortly what I had submitted earlier. Regarding the admission part, alleged admission on the part of the church official, the present petitioner, then she merely stated that she had done the authorization.
She did not admit
Yes, she
to
did not
the,
admit to it.
yes.
Yes.
Misappropriation not admitted.
Not admitted. And there
In
is
good
no...
faith. I think you have mentioned
Yes,
something in good
pecuniary
faith.
loss is there, not there. Pecuniary loss not there. And my last point is that, my Lord, this, after inquiry officer had come into conclusion, not proved, all allegations were not proved. This inquiry officer had said like that, and disciplinary authority did not accept that. But right after, like rejecting what the inquiry officer has said, then he has to hear personally the present petitioner, and that wasn't done so, my Lord. Then I am relying upon the, I had relied upon these Supreme Court judgments as well, my Lord. And hearing, it should be personal hearing. And mere giving so-called notice is not sufficient. And I had, my Lord, let me furnish these citations. I'll not go through it. For your Lordship's kind perusal, my Lord. The reason why this High Court of Karnataka is also included is that it should be personally heard.
Yes, I think you've mentioned
Yes, yes,
that
I've mentioned that,
previously.
my
no?
lord. So then I'll give more citations later, Your Lordship. With this,
No,
I mean,
whatever citations you should give.
more
Now
citations
only
regarding
more,
the
with what citations?
same
Because-
individuals in that regard, my lord, only same individuals in the appellate authority and discipline authority.
Okay.
These two citations only.
Okay, fine. Heard Mr. Bilal Ramaya, learned counsel for the petitioner. Also heard Mr. Sizoram Thana, learned counsel for the respondent. Respondents, is it?
My lord, all the respondent.
Hearing concluded, matter reserved for judgment.
Much obliged, ma'am.
Obliged.